Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is Wednesday, June 12th, 2019. The time is just after 9 o'clock a.m., and we are meeting in the hearing board room in Diamond Bar. We have one change to the calendar today. That is the hearing board general meeting has been canceled for the month so that we can accommodate more training. And we have one matter to be heard today, and that is Equilon Enterprises, LLC, doing business as Shell Oil Products, case number 4982-120 for a short variance. And who is representing Equilon Enterprises today?
Good morning, Madam Chair. My name is Ev Ashworth. I work with Ashworth Leininger Group. And with me today is Nader Solomon, who is the affiliate with Shell Carson, as well as my colleague Mike Waller.
Thank you very much, Mr. Ashworth. And who is representing the executive officer today?
Good morning, Mary Reichert on behalf of the executive officer.
Good morning, Ms. Reichert. Before we get started, I'd like to ask anyone who wishes to be heard today, including any members of the public, to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. And we also received a proposed short variance conditions, and I don't have a minute order, so I don't know what number we're up to. I mean, this should be a letter. I think it's probably B, but I don't know. B as in boy. We're going to mark those as B, exhibit B as in boy. Thank you. Excellent. Okay, thank you. We're going to get copies of the minute order at some point. But in the meantime, so we'll start with opening statements. And of course, we were here previously for the interim variance hearing. And let me ask both parties if you would like to incorporate all of the testimony and evidence from the interim hearing. Mr. Ashworth?
Yes, please.
And Ms. Reichert?
Yes.
And we were able to make all of the findings, and I think today really we need to hear just an update on status in order to make the findings and continue with a short variance. So, Mr. Ashworth, with that, if you'd like to begin your opening, please.
Thank you very much, Madam Chair. Good morning, ladies and gentlemen. Again, my name is Ev Ashworth, and I work with Ashworth Leininger Group. We're an environmental consulting firm that provides technical assistance to Shell. I'm here on behalf of Equilon Enterprises, which does business as Shell Oil Products U.S. You recall from the 14th of last month, we spoke of the need for a variance for tank number 1515. That tank is one of two tanks that contains contact water. Contact water is generated when storm water or other processed water comes in contact with the ground, and then is pumped to one of these two tanks to make sure we're protecting the environment. Routine inspections that took place back in May identified the failure of a secondary seal. That failure was such that the concentrations of organics inside the tank made it unsafe to operate. And so, as we talked about, the safe process required that we come to the board and seek a variance for the operation and repair of that tank. Simply put, we have to drain the contents. And to drain the contents, we have both water and transmix. Transmix is a general term that refers to oils that are collected or slop oils. As we'll talk today, Mr. Nader Solomon will speak to the progress that we've made and what we still need to do. Mike Waller, who's my colleague, will also speak to the excess emissions that will result as a consequence of the repairs that were taking place. And we've worked to this point with the district and worked with district staff. As you know, as part of our current conditions, we report on a daily basis to district staff, and we provide routine monitoring of the tank, which we'll go over. And so we're asking today to have a continuance of this short variance for the period through July 31st. And we've provided to the board an amended petition, which we thought would be helpful. We've modified paragraphs 16, 21, 23 and 24, which we'll go over. But in that way, you already have notes in front of you, and we thought that would be helpful to allow us to follow the documentation here. This morning, we gave copies of these to the clerk of the district, and we're, again, very appreciative for the assistance that the district clerk has provided to us.
Thank you, Mr. Ashworth. Ms. Reichart, your opening.
Thank you. Subject to the testimony presented here today and compliance with the proposed conditions, the district is not opposed to a granting of this variance. As pointed out by Ms. Byrd before the hearing, there is one correction to the proposed variance conditions marked as Exhibit B, and that is in condition number 2. The last line, it should be, but no more frequently than every 6 hours instead of 8. Thank you.
Thank you. And Mr. Ashworth, I can't recall, did you testify last time? Would you like to begin by testifying, or did you want to introduce a separate witness?
I did, Madam Chair, but I think we can move quickly through by talking to both Mr. Solomon and Mr. Waller.
Okay, then proceed as you wish.
If I may, there is a correction I would like to make on page 6 of 9 of our petition. And in paragraph 24, you'll note that we asked that the variance begin on May 14, which was the date for the interim hearing. I spoke to Ms. Diaz this morning, and that date should properly be stated as May the 5th, which is when the ex parte variance was originally granted. That's my fault, and but by correcting it, we have a total of 87 days that would be allowed for under this short variance within the 90-day period allowed for it. So if you wouldn't mind just taking out that 14 and turning it into a 5, if that change could be made, that's the only correction that we need to make. All right?
Thank you. That's so noted.
Thank you. Now I'd like to introduce Mr. Nader Solomon. Would you please state your name?
Nader Solomon,
And what is your title?
Shell Carson Terminal Manager.
And what do you do in that role?
I manage the daily operation for Carson facility.
And I know we've gone over this, but how long have you been in that position?
I've been with Shell for 18 years, at Carson since late June of 2018.
We are here to seek a continued variance for tank 1515. What kind of tank is tank 1515?
1515 is a dome tank with internal floating roof.
And what are the contents of the tank?
It's a contact water.
And what is contact water?
Contact water is mixed between rainwater and hydrocarbon.
And how's that produced at the site?
It's it collects from anywhere from the sump, anywhere in any potential places that hydrocarbon make contact with water.
And on May 14th, you described how a regularly scheduled inspection identified damage to the internal seal of tank 1515, and how a variance was required as Shell could not safely enter and repair the tank. Is that correct?
Correct.
And following the issuance of the interim variance on the 14th of May, what has Shell done to perform work on the tank itself?
After May 14th, we'll start treating water and release to PETW per permit.
And on what date did you start the removal of the water?
We started on May 15th.
Okay. And what are you doing with the contact water when you remove it from the tank itself?
We have a contractor comes on site that specializes in water treatment, and they bring their equipment on site and they treat the water to release it to PETW line per permit.
And have you completed the removal of all the water?
Water treatment was completed for tank 1515.
And now what remains within the tank itself?
The transmix, or the oil part, or the hydrocarbon part, is remain in the tank.
And how much transmix do you estimate the volume of it is within the tank?
We're estimating about 9,500 barrels,
And that equates to roughly how many gallons?
about 400,000 gallons.
And to remove the transmix, when do you plan on starting that process?
So we already started set up to transfer transmix from out of 1515. The process itself would start tomorrow.
And once you complete the removal of the transmix, then you can begin degassing the tank?
Correct. Once the volume in the tank, the roof is getting to close to landing the legs, degassing unit will be connecting to 1515.
And once you begin degassing the tank, will you expect to have any more excess emissions?
No excess emission.
All You've testified on the 14th of last month that the contents has to be transferred into a vacuum truck. Is that the only option that Shell has for transferring the transmix?
That's the only option we have because the tank is not connecting to other tanks other than the contact water next to it, which is a full tank. It's partially full.
And then you also testified on the 14th that you've fully curtailed operations to the tank. Is that still correct?
That's correct. We haven't added any contact to 1515 since we discovered that the secondary seals have a problem.
And during the transfer of the transmix oil into the vacuum truck and the temporary storage tanks, what are you doing to minimize emissions?
So the vacuum truck itself has a carbon canister on it, and the Baker tank have a carbon canister on it, and both of them are set per specialized vendor.
While the tank is being drained, are you doing anything to measure emissions from tank 1515 itself?
We continue doing a daily LEL monitoring on the tank twice a day.
And in the course of that monitoring, have you encountered any emissions as detected by the instrumentation?
There was no emission detected during that time.
And if I may, at this point, I think this would be Exhibit C. It's a copy of the LEL reading logs that have been taken from the 10th of May through Monday of this week, and all indicating that the concentrations as monitored at the hatch are non-detectable. And if I may introduce that.
Thank you. Let's pass that out, and the petitioner exhibits are numbered. So let's see what number we would, I think we're up to number 6. So this will be number 6.
That then would be Exhibit 6. Thank you very much, Madam Chair. Will you continue to monitor the hatch during the remainder period of this variance?
Yes.
And separately, are you providing daily progress reports to the district's technical staff?
We are.
And will you continue to provide those daily reports during the remainder of the variance?
We'll continue providing it.
All right. Madam Chair, that completes the testimony of Mr. Nader Solomon.
Okay, thank you. I'm going to ask Ms. Reichart if she has any questions.
Thank you. Can you just describe, I guess I'm a little confused about how the water is separated from the transmix and what's actually in the transmix?
So the water is actually, there's a density difference between the hydrocarbon and the water, and they kind of separate naturally. So the water is in the bottom of the tank, and hydrocarbon float to the top.
Okay, so they sucked the water out from underneath.
From the bottom, correct.
And then the transmix is,
Transmix is a term that the oil industry uses, which is, it's a mix of different products, jet, diesel, gasoline, all mixed together. And this is what we call transmix. Basically, it's a slop oil. It's a product of mixed different hydrocarbon.
okay. And then how long do you anticipate it will take to remove all the transmix?
So we based on the estimating we have, we're thinking that we'll be able to get on the degassing unit within a couple weeks.
Okay,
By the time we get the vacuum truck started tomorrow.
okay. Thank you. No further questions.
Board members, questions for Mr. Solomon? Yes, Mr. Balagopalan.
Yes, Mr. Solomon, there's no mention about the seals and the seal repairs. And so once you have degassed the tank, then the next step, what are the next steps, and when do you intend to inspect the seals? When do you intend to replace it, or if, and so forth?
So once we finish degassing the tank and empty the content from it, and it was zero LEL, we start disconnecting and open up the tank for cleaning. Then the tank, a crew will go in and do the inspection for the secondary seal.
And then,
Repair will start.
and I think your testimony last time was about 3 days to replace. Is that still the case for the seal?
So normally a secondary seal would take us 2-3 days to replace, but now since the tank is open, they're gonna do a full inspection on the tank.
So after the inspection is done, and then you will ascertain the damage to the seal, both the secondary and primary, or just
They will do a full inspection on the tank.
on both? And then depending on the damage to the secondary and maybe primary, then you may have to replace both, or?
They will do a full assessment. Normally what they go with the process, once the tank is open, they do a full assessment on the tank and they do a report. and they put out all that estimate together.
And how long will that take, do you know?
Repair secondary CO is few days. If they find anything else, it might take a little bit longer. Weeks, it might be weeks.
And what about the primary? If there's issues with the primary seal?
They would also replace it if they,
Same time frame you're talking about?
absolutely.
And then after the seals have been replaced, then you put water back into the tank, and then the Baker tank is also emptied back into the tank 1515?
Correct. So Baker tank, once the tank is back in repair, then it's good condition, we'll put it back in service by putting product back in it.
And so the variance is covering until you degas the tank, not beyond that, right? Because after that, it'll, when you won't need the variance, basically.
Correct.
Okay, all right, thank you.
So just on that, you're anticipating that in 2 weeks you begin degassing, is that correct?
Correct.
And in about 2 weeks, when you begin degassing, you testify that there should be no excess emissions after that point, is that correct?
Correct.
And so then you anticipate it'll take approximately a month to degas?
So that, once we go on closer to the landing, the roof is we estimated 2 weeks, but there's still volume in the tank that we need to get out of the tank. And the remaining volume, even though we're making the condition, but it takes us time to get the tank totally out of service.
Okay, so that's different than the degassing? Is that before you degas? I'm trying to understand.
No, so the degassing starts closer in roughly 2 weeks,
Yes.
and where there's no excess emission coming out of the tank. Now we're going to continue working to get the remaining hydrocarbon out of the tank.
Okay. And that will come once it's degassed, or at the same time?
It was the same time.
Okay. And that, you anticipate, takes longer?
It would take another probably couple weeks more, but
Okay.
we'll be making the permit condition within 2 weeks once we connect the degassing to the tank.
And Madam Chair, just to clarify, we've asked it to go through the end of July 31st because in our experience, there can be glitches that take place. And so we didn't want to find ourselves in a situation where we were ambitious in our schedules, only to find the vacuum truck had an issue, or the contents of the transmix was such that it provides a viscosity issue to manage. And so we thought it more prudent to ask for the longer period of time, just to be sure that we have a window to manage any of these potential issues that could arise and not have to come back and revisit for an additional period of time.
Thank you for that. Board members, other questions? Anyone else have any questions for Mr. Solomon? Okay, thank you. Thank you, Mr. Solomon. Oh, sorry, Senator has questions.
You're requesting a variance based on a petition that it would take more than 72 hours to complete the project, according to Rule 1178, Rule 463 and 1178. That's why you asked for a variance. Is that correct?
And correct, and we'll have Mr. Waller speak to the specific regulatory requirements that drive the need for this variance.
It'd be easier to follow if you were to say, well, we made some measurements, and what we measured exceed the 15% LEL level, removed personnel from the tank. Now we made a decision at some point in time, we have to drain the tank, fine. Somewhere I wrote it took 40 to 45 days to drain the tank, is that correct?
Overall, we will have to complete the draining of both liquids, water, and transmix within the maximum 90 days allowed for under a short variance. Correct. We're asking for a period of 87 days, Senator, for that to be completed.
Then if it takes that much time to go through that process, then you begin to repair. Is that also included in the total amount of time?
No, that's a good question. We will no longer have excess emissions, as Mr. Waller will testify to, once we connect the tank to degassing equipment, and at that point, excess emissions will cease, and we no longer need variance protection.
That's true based on your measurements.
Correct.
Well, yeah, we give,
Is that true? You will no longer need variance protection once there's no excess emissions? Or is it that once the tank is completely empty, you will no longer be in violation and require a variance.
Madam Chair, it's the former. Once we have this tank connected to degassing equipment, excess emissions will cease, and we will know.
That's not the question.
Okay, I'm sorry.
You could require variance protection and still not have excess emissions. Is the requirement that if you have anything in the tank, it needs to have a roof that is working and that is fully functional, et cetera? And so you continue to be in violation of a rule, regulation, permit, condition. Is that the rule?
As Mr. Waller will go through and testify, the rules 1178 and 463 allow for compliance for when we have the tank connected to a degassing operation.
Okay.
And so that we will.
So let's hear that, because then you may not need till July 31st.
No, I think and we'll go through that with Mr. Waller.
Okay, thank you. Then we'll hold those questions. Sorry, Senator, you had other questions.
All right. You have target dates initially provided, Mr. Solomon, for having completed all of these, the entire process. When was that done, the process?
The water treatment completed, Janitor, on June 5th. The water treatment was completed on June 5th.
And now you're in the process of degassing, or has that been done also?
The degassing, it hasn't started yet. The degassing, we estimated within 2 weeks we'll be able to connect the degassing unit to the tank.
What's the bottom line time frame? Within 2 weeks, that's all the variable. When you expect to have that done?
It's around mid-July, Senator, I think is very conservative. I think once we start using the hydrocarbon, which will start tomorrow, we'll have a better estimate when we'll be able to connect degassing to the tank.
All right.
Ms. Byrd?
I just wanted to ask again, if you mentioned that there were certain numbers in your petition where the changes took place. Would you just point that out for us?
Correct. What we tried to do, Commissioner Byrd, is to update the status of the progress that Shell has made. And so we've modified paragraph 16.
Can you tell me which specific thing you modified in each of those paragraphs?
In paragraph 16, what we've explained that we're doing is to explain how it is we've determined the contents of the tank and the volumes of the tank, and the procedures by which we intend to remove the water and the transmix oil in greater detail than we provided initially.
Okay.
In paragraph number 21, we've provided to the district a description of the vacuum truck and the portable tanks that will be used and how they will be equipped with carbon controls. In paragraph number 23, we've provided a bullet list of 4 bullet action items that break down the process by which we intend to remove the contents of the tank itself. And we also provide the cost estimate for this project, which is asked for as part of this question number 23. And then finally, in 24, what we've done is to revise the timing for which this short variance would be in place. It would go from May 5th through the 31st of July, allowing for a total of 87 days of variance coverage.
Okay.
And those are the changes that we made.
All right, thank you. I just
Thank
wanted
you.
to make sure I didn't miss anything.
Senator?
Excuse me, sir? It would be the 31st of July. So it would be a total, Senator, it would be a total of 87 days as opposed to the 78 that's expressed there in the text.
Any other questions for Mr. Solomon before we move on to the next witness? Thank you. You may introduce your next witness.
Thank you, Madam Chair. Mr. Waller, could you please state your name?
My name is Michael Waller,
And what is your title?
Senior Engineer,
And with whom do you work?
Ashworth Leininger Group.
And if you might, I know you discussed this on the 14th last month, but could you describe the emissions that are typically associated with tank 1515 when it's under normal operations?
I can, just one moment to get that out. So tank 1515, under normal operations, when it contains both the primary and secondary seal, is estimated to be 273.6 pounds per month using the EPA tanks emissions estimating tool.
And that's provided in Appendix B of the petition that we've, the amended petition that's been provided to the hearing board, correct?
That's correct.
And so you testified on the 14th of May that there are excess emissions now as a result of the failure of the secondary seal. You estimated that at 7.1 pounds per day, is that correct?
That is correct.
And that's set out in Appendix B as well, correct?
That is correct.
And is this 7.1 pound per day excess emission estimate still appropriate for the remainder of the period of the short variance?
Yes, it is. The secondary seal has not yet been repaired, and there still is, as Mr. Solomon testified, there's still product or transmix remaining in the tank. So that calculation remains valid.
And during this period, will Shell continue to violate the regulations which we've identified in the interim variance?
Yes, they will.
And if you might briefly summarize the specific permit terms and conditions that are, for which Shell, the tank 1515 will be in violation.
Yes, I can do that. Under both, there are some general permit terms and conditions, such as Rules 203, Rules 2004 and 3002, which generally state that Shell must comply with all permit terms and conditions applicable to this tank. Specifically, also in the permit is condition S13.2, which identifies Rules 463, 1149, and as 1178 as applicable. And then drilling that down a little bit more, if we go into Rules 463 and 1178, both Rules 463 and 1178 require that this tank have two seals, a primary and a secondary seal, that are one above the other and intact with no visible gaps. And then if there is a failure in the seal system, that the seal system be repaired within 72 hours. Additionally, if there is, during an inspection, a defect identified, then Shell was required to submit their full inspection report to the AQMD within 120 hours of discovery.
All right. And earlier this morning, the chair indicated as to what is the driving force for the violation of these regulations. Is it the excess emissions themselves, or is it the failure to provide a proper secondary storage and seals?
The driver is that we do not have a secondary seal in place, which is a requirement of both the permit and Rules 463 and 1178.
And so when we connect the tank to a degassing equipment and the excess emissions stop, why is that a bright line that we think identifies a point at which continued compliance with the variance is no longer required?
Under Rule 463, it requires that both seals remain intact except during periods of complete empty and repair. So Rule 463 does actually allow us to be in compliance when we're doing a complete empty and repair. Rule 1178 is not explicit in that manner. However, district inspection staff have historically interpreted that once you're on degassing equipment, you've met the requirements of this rule because you are connected to a control device.
So then it's the practical application of the rules and the application of the degassing equipment that allows us to claim that we're now in compliance with the underlying regulations.
That is correct.
And we would be happy to work that with your engineering staff, Ms. Reichart, if that's an issue that you see deserves additional attention. But this is how we've interpreted this provision at the Shell facility for the period of time that we've been working with Shell. And this is a routine operation for repair when we attach to degassing. And in those instances, we've not asked for variance coverage in those cases where we have been able to attach the tank to degassing. All right.
That's
I'm
correct.
sorry, Mr. Waller, if you could say yes, if your
Yes.
answer is yes.
Yes.
All right. And so Earlier this morning, you heard from Mr. Solomon that the transfer of transmix from tank 1515 will require pumping into a vacuum trunk, which will be equipped with carbon canisters, and then stored temporarily in portable Baker tanks, which will also be equipped with carbon canisters. Are there any excess VOC emissions from this transfer and storage?
No, there are not.
Why not?
Because under Rule 1149, the vacuum trucks are regulated in both how they operate and the amount of emissions that they can emit through their carbon unit, and these vacuum trucks will operate in accordance with Rule 1149. And then as far as the Baker tanks go, they are equipped with permits from the South Coast Air Quality Management District and also equipped with carbon canisters. So when the product is stored in these Baker tanks, Shell will comply with all permit terms and conditions applicable to those Baker tanks.
Thank you. Mr. Waller, in your opinion, what would Shell do if interim variance is not granted?
Shell would continue to remove the product out of this tank 1515 in the same manner.
And that's to assure that the tank could be entered safely.
That's correct.
All right. And you previously discussed the regulatory requirements that are underlying the need for this variance. What would be the consequence if we failed to achieve the variance from the district today?
Shell would be non-compliant with these permit terms and conditions.
And if we fail to have a variance, would the emissions from the tank change in any way?
No, the emissions would remain the same regardless of issuance of this variance.
Well, and why not?
Because the fact remains that there's still product in this tank, and that causes emissions from this tank, and Shell is doing everything that it can to remove the product as quickly as possible, but until it's removed from this tank and connected to degassing equipment, it will continue to emit regardless.
And Mr. Waller, in your opinion, does Shell have any other options available for achieving compliance that have you not described so far?
Not that I'm aware of.
And Madam Chair, that completes Shell's presentation for this morning.
Thank you. Ms. Reichart, questions for Mr. Waller?
Thank you. So I think I'm still a little unclear. Is it your position that once the degassing equipment is connected, that you are no longer in violation?
Rule 463 has an explicit paragraph that says that the seals must be intact and the roof must be floating on top of the surface of the liquid at all times except for during empty and degassing. Rule 1178 does not explicitly state that provision. Once we are connected to the degassing equipment serves as the control for the organics that are in this tank. So it is our position that once it's connected to control, we are controlled and we're following the provisions of Rule 1149.
Okay, so once the degassing equipment is attached, you're in compliance with 1178. But then why wouldn't you fall under the provision of 463 that says you can, during the emptying and degassing, that it doesn't have to be floating on, or the seals don't have to be intact?
I just want to get the rule language here. I'm not saying that we're not in compliance with Rule 463 at that time. I was saying 463 explicitly allows us to land the roof, and so the roof is no longer resting on the product. And 463 specifically allows us to do that when we're emptying materials from the tank.
Right, so what I'm trying to identify is exactly when you'll be in compliance and when variance coverage would no longer be needed. Because if you need to complete the degassing to be in compliance, that's a much longer period of time than if once you commence degassing, you consider yourself in compliance with the rules.
I think I understand. No, it is our position that we would be in compliance once we commence the degassing operation, because we would be operating now under a Rule 1149 compliance requirement.
Okay, so that would really only be in a couple of weeks, because that's when you're going to start degassing?
That is correct. We would anticipate achieving compliance in the next couple of weeks.
Okay, so would the end date need to be adjusted to more like the end of June?
Well, again, as we expressed earlier, our concern is there may be unforeseen events that take place with a vacuum truck, with a pump, which may potentially happen. So we,
May I suggest, if that's the concern, that you look for a variance that ends either when degassing begins or in no event later than 90 days, which allows you for that flexibility but ends upon degassing.
good. And I think, and thank you for that suggestion. The concern is that we've seen there are periods of time when degassing starts and then it stops again. So it's a start-stop scenario. And so we appreciate the suggestion that you have for that. And so we're concerned that if something were to arise where there's a decision to make, where we have to continue to pump out some material, which could potentially happen, we might be in a situation where we'd have to come back to you again on an emergency basis to then do this. So we're happy to take the suggestion of the board here. Our thought was to try to limit ourselves within the 90-day scope of the short variance, but then provide enough margin of safety so we wouldn't have to require additional attention of the district or the hearing board. But it's your pleasure.
So I have a clarifying question, but I don't know if, if it really would go back to Mr. Solomon about exactly what would happen, but I don't know how you want to.
Oh, you mean to go back to Mr. Solomon?
Well-
I think at this point you can, especially because, Mr. Ashworth took the oath and he's also sort of testifying. So please, if you have a particular question that's going to help in this matter, or just ask.
Okay, thank you. So whoever would answer this, my question is, it sounds like I initially thought when you had testified about the degassing that once the degassing starts, the degassing will continue all the way until the tank is empty, and that there may also be concurrently some removal of additional product. But then it sounds like perhaps maybe that's not the case, that the degassing equipment would be removed and then to allow the removal of product. So maybe if you could address that contingency or what might happen during that.
The plan is the degassing, once we connect the degassing, we'll continue on the tank till it's empty or LEL free.
Okay.
That's traditionally how it's getting set up and getting, once we're getting closer to landing the roof, it's required to have the degassing, and it would continue connecting to the tank until the tank is liquid free.
Okay, but it sounds like Mr. Ashwood is saying that there could be some unknown contingency or something that happens that's unpredictable that would cause you to need to remove the degassing equipment in order to do something.
Unless we have an interruption in the vacuuming process, removing the liquid out of the tank. Otherwise, we'll continue removing the liquid and having the degassing connecting at the same time.
Okay. So is it your position that you would want to continue to have coverage once degassing commences because there's a potential for you needing to remove the degassing equipment?
No, it's more, my position is more into how long you're gonna get to connecting the degassing unit, because the vacuum truck, it will continue removing liquid out of the tank. We're estimating a couple weeks, but I'm not really sure if this process is gonna take a little bit longer to connect the degassing unit to the tank.
Okay.
So then, as the chair suggested, we could go with her suggestion, connected degassing.
Yeah, so would it be your position that it would be acceptable to have the variance last until the degassing equipment is attached, or 90 days, whichever occurs first?
I'm okay with that
Okay,
idea.
all right, thank you.
Thank you. Board members, any other questions for Mr. Waller first? And if not, then we can, if you have any remaining questions, we can go back to other witnesses. Senator.
He just explained that in the process of degassing, there may be some reason or cause you to have to stop degassing. And what are some of the reasons that you would stop degassing?
Just for the record, Mr. Solomon, you'll be answering that, correct?
Correct.
Okay, thank you.
Senator, what we do is we bring a specialized vendor to operate the combustion unit that degas the tank, and the responsibility is to the operation of the unit, and they will report to us if they have any operational issue with the unit and they need to stop.
What are some of the issues that cause them to stop?
It's combustion unit, a blower goes down, a motor goes down, they have electrical problem, this kind of technical problem with the unit itself.
So it's not fail-safe?
No, it is, Senator. We've been using it on site for a long time. They're specialized and permitted vendor. It's just when things happen, they have to report it to us and report it to the board.
Degassing began when all the fluid and liquid is out of the tank, or concurrently?
No, degassing happened when the roof legs, it touches the tank floor or closer to it, right before it does. And this is a degassing unit to remove the excess vapor out of the tank.
At that time?
Yes.
Thank you.
Any other questions, Mr. Balagopalan?
Yeah, so when you're degassing, you don't anticipate any exceedance of the limits specified in 1149?
No, we do not.
They'll-
The contractor is aware of the limits as well as Shell and operate accordingly.
And in the past, have they had any exceedances of the outlet measurements exceeding the limits in the rule? Do you know?
I'm not aware of any exceedances of the limits. I am aware that there have, like Mr. Solomon has testified, that there have been some operational hiccups where there was an electrical problem or a blower failure, and they have had to bring in an alternate unit to continue the degassing process.
Going back to the, when you're taking the transmix out from the tank into the Baker and storage units, those are vented to a carbon absorber, you said?
Yes, they are. They are permitted by the South Coast
And
Air
what-
Quality Management District to vent to carbon.
What's the efficiency estimated of the carbon unit?
That, I don't know. That would be permit specific and would have been evaluated by the South Coast Air Quality Management District at the time of permit issuance. But as a guess, I would assume 95% control or better.
So would you consider that 5%, assuming it's 95, excess emission, or does a permit allow that?
The Baker tanks have their own permit, so once the material is in the Baker tank, the Baker tanks assume, not assume that compliance, but the material's in that tank, and so we must comply with the permit terms and conditions that are applicable to that tank at that time. And no longer is the material subject to the permit terms and conditions of tank 1515 because it's no longer being stored in tank 1515.
Are they emission limits in the permits? Are you aware of any?
I have not looked at the permit terms and conditions for these Baker tanks, so I can't speak specifically, but typically they have a concentration limitation of around 500 ppm effluent, and there's a frequency in which they must monitor.
Right. So if the emissions are, if it's 500 ppm, if it exceeds that, would you consider that as excess emissions then during the operation?
Typically not. At that point in time, they're required to change out the carbon bed on those tanks and continue to store the material.
So they'll be monitored?
That's correct.
Okay, thank you.
Ms. Byrd and then Senator.
Just to follow up, I wanted to make sure I understood this concept of the degassing, connecting the unit and ending the variance. When those hiccups occur, and I'm not sure who would answer this, when those hiccups occur, are you saying that you do not disconnect the equipment? Is it just a repair of the equipment that is connected, and so there are no emissions that would be coming out? Do you understand what I'm saying?
It's
I'm
really
trying to
dependent
follow.
upon the problem. Oftentimes, it's an electrical issue that can be repaired quickly, and they can reset the unit, restart it. So no, we wouldn't disconnect the whole degassing equipment from the storage tank. There have been, in my experience over the years with clients, there have been occasions when they had to bring in a whole brand-new degassing unit to continue the operation.
Okay. And I guess I'm trying to follow the issue of when the variance would end in the event that that happened.
So it's a very good question. If we did have to discontinue the degassing operation for whatever reason, if it's no longer pulling the vapors off of those tanks, then tank 1515 would again be in a non-compliant situation, and we would need variance coverage.
Okay, yeah.
Is it immediately non-compliant, or is there still that safe harbor timeframe for repair, or that doesn't, that no longer would apply?
In my opinion, this is just my opinion, the 72-hour repair period began on May 2nd when we discovered the issue.
Okay, thank you. Senator, you have a question?
You built in some lead time anticipating a failure, is that not correct?
I don't know that we anticipated a failure. We were seeking not to come into the hearing board again to say, hey, we had an electrical failure, we need an additional variance coverage.
I think the attorney stated that, words to that effect. We added more time to the variance for completion of the process because we anticipate there will be failures.
That's not how I
Well, sitting right there.
view it.
That's not,
Let's let Mr. Ashworth answer, because that's not how I heard it. Mr. Ashworth, would you like to clarify what you said?
Just to clarify, Senator, I'm not an attorney, I'm a technical consultant for Shell, but it's just our experience that these degassing operations have had issues in the past where the equipment had a trip. We refer to a trip as when some element doesn't work. It's, the frequency of that is small, but we know it does happen. And so it was our thinking that recognizing this is a potential issue, not to say it will happen, but in the event it does happen, we didn't want to find ourselves again in front of you explaining that, well, we could have written this condition in a better way to avoid having to come into the district.
Right.
We would defer to you on how you want to write this condition. It's
so
really
we
your
have
choice.
trips that may occur, and therefore we're asking for July 31st completion date. But if trips did not occur, it could be sooner. So therefore, the variance could state, Madam Chair, that July 31st or sooner, this project could be complete. Is that not correct? Is that what you're saying?
And again, yes, and we would defer to how you would like to structure this
Okay,
variance.
thank you.
It's really your selection. But to be clear, if we were to have a trip on the degassing unit and we're not covered, we would have to come in and ask for an emergency variance in a peer review. We think the potential for that is very low.
And that's very helpful to know, to frame our discussion. Any other question, Mr. Balagopalan?
Yeah, just as a follow-up, Mr. Ashworth, you can respond to that. So given that, assuming nothing happens to the degassing unit, when do you anticipate completing the project? Getting the tank degassed and,
I would defer to Mr. Solomon if I may,
Solomon,
sir.
okay, sorry.
We're estimating a couple weeks to get to connecting degassing unit and another 2 weeks to totally empty the tank estimate.
So,
Best case scenario, everything that worked properly with the vacuum truck and the transfer.
so that will be before July 31st then?
Correct.
And so in case something does happen, you can do, the repairs can be done within a few days or whatever, depending on the extent?
That's correct.
Okay, so having the coverage till the end of July takes care of any unforeseen event occurring?
That's correct.
Okay, thank you.
Any other questions for any of the witnesses before we turn it? I don't believe Ms. Reichart has any witnesses. So before we end all testimony, thank you. Seeing none, thank you all. Ms. Reichart has no witnesses.
Correct.
Okay. Would any member of the public wish to be heard on this matter? I see none. Mr. Ashworth, would you like to give a closing statement?
Thank you very much, Madam Chair. As we spoke on the 14th of May and again here today, I think Shell has demonstrated that a short variance should be granted through the period of July 31st. But we note that if you would prefer to condition it differently, we would defer to your judgment on that. There's 6 elements that we have to show to establish the short variance. I thought I'd hit them briefly and in sequence. First, as Mr. Waller testified and consistent with the interim variance, Shell is now, as a result of the failure of the secondary seal, in violation of specific district regulations and its Title V permit. And those are summarized in the current interim variance that was issued on the 14th of May, and I'd be happy to work through those briefly, Madam Chair, or just adopt them by reference. I defer to you.
It's up to you if you want to. I'm going to and during deliberations, I think I'm going to defer to that, to our findings, so it's up to you.
And so briefly, condition S13.2 applies to rules 463, 1149, and 1178. And as Mr. Solomon stated, because the repairs could not be completed within 72 hours, tank 1515 is in violation of these requirements. 463C2, E4, F1C all require that the tank have specific components and that they be in good working order. And if they cannot be completely repaired within 72 hours, or reports filed within 120 hours of the event, we would be in violation of those specific provisions. And as we testified earlier, because of the elevated lower explosive limit readings, we had to remove personnel from the tank and could not complete those repairs within the 72 hours, nor could we submit the reports showing that we were completed. 1178D2, Section G and H4 all require that the components of the tank operate properly. And as we testified, the secondary seal has been compromised. And again, we can't completely empty the contents and repair within 72 hours, nor submit the reports within 120 hours as required by those rules. And finally, Rule 203B, the Title V provisions 2004 F1 and 3002 C1 all require that you have to operate in compliance with your Title V permit. Again, the compromised seal and the inability to repair that within the timeframes means we're in violation of that rule as well. Second, we have to demonstrate due to circumstances beyond Shell's reasonable control that requiring compliance would impose an unreasonable burden. As we spoke in detail on the 14th of May, requiring Shell has really done this for purposes of safety. We cannot safely enter the tank with a compromised seal and must remove the contents of the tank. To require us to move quickly would put our Shell, our contractors, and potentially the community at risk. As explained by on the third point, as explained by both Mr. Solomon and Mr. Waller, requiring immediate compliance with applicable district regulations and the Title V permit would have no corresponding benefit in reducing air contaminants. As we explained, the tank is compromised, and while we're monitoring the lower explosive limit at the hatch, excess emissions will continue until we repair the tank itself. We will, and our fourth point is that we're doing everything we can and that is feasible to minimize emissions. When we found tank 1515 to be compromised, we immediately ceased sending contact water to the tank. Recall, we have 2 at the site, and we divert all contact water to the other. So it's out of service for the purposes of its process. On the fifth point, during the period, we're going to minimize emissions to the maximum extent possible. Our condition requires that we monitor at the hatch, and we've detected no hydrocarbons at the hatch. As Mr. Waller testified, the calculations to be used to indicate the compromised secondary seal would suggest a maximum emissions of 7.1 pounds per day. We are also, as explained by Mr. Solomon, putting forth a transfer of contents through vacuum trucks and portable storage tanks that are fully equipped with controls and will minimize emissions. And number 6, we will continue to monitor emissions and also provide daily updates to the district as provided by Exhibit B, and we will continue to do that till the term of the variance. And we thank you very much for your attention in this matter, and we'd be happy to provide any further clarification on the terms of the conditions as well. Then that concludes our presentation.
Thank you. Ms. Reichart, your closing.
Thank you. With all of the back and forth about the potential end date, I think that my opinion of it is that once the degassing equipment is attached, as was testified, there's no further excess emissions. So in order to give some flexibility in the event that there is some sort of power interruption or unexpected event that would cause them to have to detach the degassing equipment, that it's our opinion that we are not opposed to the variance extending through the 90-day period or as soon as they do achieve final compliance. So with that, subject to compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Thank you. And board members will recall that we were able to make all of the findings for an interim variance in this matter, and the situation has not changed in terms of what brought us here or why the tank has to be emptied because of the LEL readings that were found. The fact that that water had to be treated took some time, but it's good to see that they are moving rapidly, and that has been done, and we're almost to the point of attaching the degassing. So the only question we really have is, have the findings changed moving forward, and how, and to discuss that, because beyond reasonable control was already covered. In terms of any unreasonable taking of property, it is really just being in violation at this point, and because they will have to, the tank is as it is, if it's not repaired, those emissions are occurring. So it's just a matter of whether they would be subject to fines, which could mount. The taking or closing would be without a corresponding benefit in reducing air contaminants. We were able to find that at 7.1 pounds per day? And that's VOC, correct? Thank you. Which is the upper limit. And again, there's no hydrocarbon readings at the hatch, and but that's the rough estimate. And as we were able to find, we were able to make that balance in finding number 3, that the closing or taking would be without a corresponding benefit in reducing air contaminants, and that this is moving quickly and will soon have no excess emissions. Consideration to curtailing, that is not an option still. And reducing excess emissions to the maximum extent feasible. Again, unlike last time where we still had 40 to 45 days to go, at this point we have the estimate is about 2 more weeks before the degassing is hooked up. There's nothing else that can be done other than that, and so they are moving as expeditiously as possible to reduce those excess emissions, and monitoring as was required under the conditions of the interim variance, which will continue. And so I can continue to make the findings. I do agree, once I make a motion, that given that it is anticipated very strongly that in 2 weeks there will be no excess emissions, and that any trips are unlikely, and so they should probably stay in, that I don't see any reason why we shouldn't give what's a little bit less than the full 90 days, just to make sure that they don't have to appear back here again on an emergency. Anyone else have any thoughts? Mr. Balagopalan?
No, I agree. I think with all what you said, and it looks like after the interim variance was granted on the May 14th, they, as per what they had indicated, they had completed the transfer of treated the water out, and then they're ready to do the transmix, it looks like tomorrow. And then they did say in the petition 10 to maybe 2 weeks to complete that. I think we ascertained that once they connect the degassing equipment, then the variance, technically, they don't need the coverage, the variance, basically. So I think putting the condition that you suggested, whichever is sooner, 90 days, or once the degassing equipment is connected, then it ends, would be appropriate,
Do you think that's appropriate? I was thinking more until final compliance or 90 days, because the issue is once the degassing equipment is attached, they are in compliance, but there could be a trip or a failure. And so if we say it ends at the connection, then if that trip happens, then the variance would already have ended. So do you agree with, do you feel that it?
Yeah, I'm wondering at that time, they, if that happens, whether they violate 1149, not, also then, if that's going to occur, then they could be violating the degassing rule, which is not been covered here.
Right, well, but that, they're not asking for a variance from that.
So I'm just, it all depends on the nature of what occurs, so No, but it's fine. I'm okay with, going full 90 days.
Ms. Byrd?
I would agree to give them the full 90 days, or actually, they're asking for 87 days, but to accommodate whether or not there are any hiccups. The best case scenario would be, I think, 2 weeks to get it degassed, 2 weeks to clean it out. If anything, and that would be a month anyway, but if anything happens in the interim, rather than them come back, I don't think it's unreasonable to give them a couple weeks more to accommodate that.
Senator?
To add more discussion on the time allocated for the variance, I think it's important to note again here that until compliance or until July 31st or sooner, if there's no hiccups. That's what you're building in right there. So it could be done sooner. If that being the case, then let's include that language, I think, Madam Chair. When I look at the proposed variances, you have at number 2, where you said that every 12-hour shift, at least twice per 24-hour period, but no more than every 6 hours, not 8. You fine-tuned it to 6. When we look at number 3, it says you got to do it every hour. Is there a conflict? LEL,
No, this is different. 2 is monitoring and frequency of monitoring. 3 is advising and within how long, within an hour of LEL levels exceeding 10%, the AQMD must be notified.
right, the monitoring, you won't know unless you're monitoring the deal. And that's what you're doing.
Yes, but the 1 hour does not refer to intervals of monitoring, just how long they have to alert the district.
And then if you refer to the last line, maybe that's what he's,
Yeah.
that it says,
You-
if,
In order to get to 10%, you got to be monitoring it. Otherwise, you never know when you get to 10%.
that's only triggered.
That's only triggered if it goes above 10%. So the way that this should read, and maybe if it's not
Yeah.
clear, we should clarify, but in condition number 2, that's the normal monitoring intervals.
Okay.
In 3, if it goes above 10% ever, they have to contact the district, and then in addition, then they begin 1 hour until it drops below the 10%. So it's
Right.
not in conflict.
But at some point in time, you may have dropped below 10% during that 6-hour period when you're monitoring. So it'd be less than, say, 4 hours during the monitoring, and it'll just below 10%, but you won't know it until you do it every 6 hours, no more.
I'm not sure I understand.
Okay.
Generally speaking, we received Exhibit 6, which shows LEL readings have been 0 at the hatch. So condition 2 requires those LEL readings every
6 hours.
6 hours, at least twice per 24 hour, but no more frequently than every 6, as it is laid out in number 2. Should an LEL reading be 10%, then first they'll have to monitor every hour until it drops below that 10%.
So you won't discover that it's higher, above 10%, if you're doing it every 6 hours. And sometimes it may be above 10% or less than 10%, but you don't know until you monitor within that 6-hour period.
Do you believe more has to be when you're looking at a log which shows 0 consistently? I think these were the same conditions we had for the interim, and I think we determined that, or the district told us that would be enough.
You are going to discover that 2 will be applicable long before you determine that it's less than 10% or less. And as much as it could be applicable, it would not be noticed to take action until you discover that's the case.
I'm not sure what I don't
You
understand.
don't follow the logic.
No, because it is below 10% consistently. If during one of their regular readings that we are requiring, as per this variance, it is determined to be 10% or above, that's when the hourly readings go into effect. Because we understood that the LEL, it's not safe unless it's below 10%.
At the offset, it's going to be in excess of 10%,
It is not.
period.
What, you're saying now it is?
Well, at this point in time, it's above 10%.
It is not, it is 0.
Zero? Okay, well,
Exhibit
fine.
6 says 0. Oh, okay.
And I think if I add, I think because they're taking the measurements at the hatch, you're getting 0, but it's probably in some of the other areas might be, but it's unsafe to go there and measure it. But at the hatch where they can measure, it's showing 0.
Above 10%.
Yeah,
That's
it could be,
right.
but they cannot safely get down there to measure it because of safety concerns.
That's right, and I think the confusion perhaps comes from the last hearing, that initial 15%, or it was higher, was not at the hatch. And now they cannot take readings other than at the hatch. So it's at the hatch that is the operative location for now.
Just one other, I know petitioner mentioned that they're both transferring their transmix into the Baker units tanks that are permitted by the, or contractor who has a permit, and also the degassing tank is also permitted. I wonder whether we should put some conditions saying they should operate both of this with, with equipment that have been permitted by the AQMD.
I think that's just restating what they would otherwise have to do.
Right. Because, yeah, other rules govern and the permit condition governs, But if I'm not doubting that they are going to use AQMD approved permitted equipment, for the degassing and also for the transmix, Whether we should just explicitly say what they've already stated, whether it's necessary or not.
So you want a condition that says to use AQMD permitted equipment for degassing?
And for the transfer of the transmix oil into the Baker tanks. Because both of them, they said, they are using AQMD permitted, I think it's from a contractor. I don't think I'm not sure if it's permitted by the facility, but I think they're hiring a contractor who has an AQMD approved permit that is, been utilized.
I don't see any harm in putting it in, if we want to ask the parties if they're okay with adding those conditions. I think it restates what they have to already do by law, but,
Right, yeah.
but if it makes you feel more comfortable, I don't see any reason why we couldn't add it. We haven't made a motion yet, but
Yeah.
that way we,
That sometimes the contractors let that permit expire, even though they have a permit, it's not active anyway, just,
okay. Mr. Ashworth?
I think we can, I think if I understood your concern, we will comply with all district regulations in the transfer of the oil in temporary storage, and I think we could write it in that way. I think that would address the concern you have. The district, so Shell commits to complying with all district regulations as applicable to the transfer in temporary storage of liquids that are removed from tank 1515
and the degassing.
and the degassing of the tank itself. Sure, I think that, and of course, we're committed to doing that. And so,
Okay, so wait, let's do that more slowly. Petitioner shall comply with all district regulations as applicable to the transfer of all liquid,
transfer and storage.
Transfer and storage.
And temporary storage of all liquids removed from tank 1515 and the degassing of the tank itself. if that would work for you, sir. That's what we're committed to do.
And I'll just ask Ms. Reichardt if she said any reason why that should not be added.
Other than the fact that generally we don't include additional conditions to require compliance with district rules, but otherwise, we have no objection.
Okay, thank you. Any other thoughts? Senator?
Are these readings on this, was marked as an exhibit? LEL readings?
Yes, I marked it as Exhibit 6. You may have missed that while it was being passed out, Exhibit 6.
Okay, fine. Exhibit 6, these measurements are taken at what part of the tank?
The testimony was they are taken from the hatch.
The hatch. Is that a safe time for the employees to go in and start talking about repairs?
We have closed the test, we've closed the record. Did you have more questions, or I'm sure we have the answer.
I think I'm looking for an explanation for between 2 and 3. That's what I'm saying is 0. But would they advise the employees to go back, enter the tank again at 0 level at the hatch?
No, they are not. They are not entering the tank.
That's right.
They have decided, once they read the readings at 15%, they weren't at the hatch, they were inside the tank, they evacuated, that's what we heard at the last hearing, they evacuated and determined that this tank had to be emptied and degassed before they could do any repairs.
At what point then will 2 apply, will you get to down to 10%?
It should not go to 10%, but that condition is there in the chance it does happen.
It's 10% because they taking the water out and degassing simultaneously, should be taking some readings at that point in time, determine what the LEL level is at some reduction level in the tank.
And it was explained to us that at the hatch was an appropriate place until the degassing and the liquid are drained from the tank. Did you want to reopen and ask that again?
I'd like to reopen and have them make a statement regarding at what level, when you reduce it from 15% LEL to less than 10% or lower, that you can advise the staff to go back into the tank.
We just need three board members to open. We have 3 board members. Okay, so
If I may summarize briefly, an LEL reading is simply that. It determines the concentration of hydrocarbons where the instrument is measuring. In the case of tank 1515, we initially measured the LEL readings when staff and contractors were on the floor of the floating roof. They were inside the tank, proximate to the secondary seal, and they determined concentrations in excess of Shell's safety threshold and immediately left the premise, removed themselves from the tank and then assessed the situation. So the initial reading, which triggered the safety concern, Senator, was taken consistent with Shell's safety practices while workers were proximate to the secondary seal on the floating roof itself.
And will you be taking those measurements at that level rather than at the hatch and providing us some readings?
No, sir. No, sir. Our procedures do not allow for personnel to enter that tank at any time until the tank itself is drained of its contents and properly degassed. No staff are allowed to enter that tank until the tank itself is emptied and the contents are degassed.
At that point, you take measurements. Is that correct for LEL?
Once we complete the removal of the liquid contents and complete the degassing, additional measurements will be made on inside the tank once it's determined to be safe.
And what level? For the seals?
We will take samples throughout the work area, consistent with the sampling practices.
The seals repair is the work area. Is that not correct?
Correct. But we're not going to enter that tank until it's safe to do so, sir.
Well,
We're not going to enter the
just
tank.
to suggest to me, Exhibit 6 is safe at that level.
No, well, that's inconsistent with Shell's practices.
That is correct.
So
You won't
suggest-
really know until you take measurements lower than what's you've illustrated in Exhibit 6.
And I think, Senator, what we're trying to adhere to is a safety policy which was developed after years of study of the industry. When workers are inside of a tank and we identify elevated concentrations, the most appropriate thing to do is to remove personnel, fully empty the contents of the tank, degas the tank, and allow for the hydrocarbons to be removed, allowing for safe reentry. At no point, we don't gain any, the information at that point as to LEL readings is not necessary to confirm how to continue to operate that safely.
What instrumentation you use to take the LEL level at the seal level?
It's a portable hydrocarbon sampler. It determines the concentration of hydrocarbons as a percent.
So it could at some point in time be above whatever percent is. When you make a comparison between at the very top, the cap, there's a difference
We
in that
understand.
measurement.
The reason why we're sampling at the hatch itself, as opposed to the surface of the floating roof, is to assure ourselves that excess emissions are being minimized to the maximum extent possible. At that point in time, our LEL readings has nothing to do with safety of the workers, but rather enforcement of the interim variance conditions. And we're providing data to the board and to the staff to show that our excess emission calculations, which are conservative, that the emissions as being monitored would suggest we have zero emissions coming off the tank because of that. The purpose of the condition number 3 is not for safety. It's just to demonstrate that we're minimizing excess emissions to the maximum extent possible.
So you're clearly stating that Exhibit 6, notwithstanding these readings, or considering these readings, you would not advise an employee to go back into the tank with just these readings alone.
Correct.
You would not advise, okay, that's the point.
And we did have those readings at the last hearing. It were 0 or lower at the hatch. Okay.
But Senator, we very much appreciate your concern for worker safety as well, which I think is driving your questions. And we are behaving as we think best to assure that there's no additional risk based on the way in which we're draining the tank and then repairing it.
Okay. We're going to reclose the hearing?
You're right, there's no risk, it's just the testimony is the part of the record. The guy's not gonna get sick, and then if he does, there's a record.
I'm sorry. Can we reclose the record?
Go ahead.
Okay. Okay, the record is closed, and unless there's any additional discussion, I'm going to make a motion. In the matter of Equilon Enterprises LLC, doing business as Shell Oil Products, U.S. Carson Terminal, case number 4982-120, I move that we grant a short variance, which would begin today and go until July 31st or until final compliance, whichever occurs first. It is for the tank 1515, which is at 20945 South Wilmington Avenue in Carson, and it is from Rules 203B, 2004 F1, 3002C1, specifically from Section D, condition number S 13.2 of the facilities reclaim, of their Title V reclaim permit, from Rule 463C2, 463E4, 463F1C, and 1178 D2, G, and H4. And I further move that we incorporate the proposed short variance conditions of Exhibit B with the two following changes. One is that we change, as discussed in condition number 2, 8 hours to 6 hours. And I'm going to add in the line for, I was going to say July 31st, but the variance may end before then. So why don't we do the 15 days? Do you know, Madam Clerk, what that would be? June 27th? Okay, so let's put June 27th, 2019, and if there are any additional excess emissions that were otherwise unanticipated, that can be incorporated later in adjustments. The excess emissions are anticipated to be no more than 7.1 pounds per day VOC when the degassing unit is not attached to the tank. And that completes my motion. Is there sorry? Oh, sorry. And I will be adding, so condition 5 will become condition 6, and I'm going to add a condition number 5, which will state, petitioner shall comply with all district regulations. Sorry. Did you have okay. With all district regulations applicable to the transfer and temporary storage of all liquids removed from tank 1515 and the degassing of the tank. I'm sorry? Oh, okay, you're writing it down. Let me start from the beginning. Petitioner shall comply with all district regulations applicable to the transfer and temporary storage of all liquids removed from tank 1515 and the degassing of the tank. And that completes my motion. Is there a second?
I'll second.
Okay, Mr. Balagopalan seconds. Is there a discussion on that motion? Seeing none, Senator, how do you vote? Votes yes. Ms. Byrd?
Yes.
Mr. Balagopalan?
Yes.
I vote yes. Motion passes 4-0. Thank you. Good luck, and I hope nothing trips. Any other business before we adjourn and take up training? Okay, board members, let's take a 15-minute break, and we're in CC. No, we're not in CC8. Do we know where we are? Oh, we don't know. We'll figure out where we are. We are adjourned.